Hi there, it's John Crotts, attorney at King Law and certified elder law specialist. Wanted to talk to you today about what happens exactly if you die without a will in North Carolina. It may be a different outcome than you think. So before you or your family plan on dying without a will, you may want to consider what that actually looks like. Um, the fancy legal terminology for dying without a will is something we call intestacy or dying intestate. Um, and if you die intestate, state law determines what happens to your assets and who inherits them. The court could possibly appoint a personal representative over your estate who you would not trust, who you would not agree to serve as your personal representative had you selected a choice in your will. So that's reason number one. But who would actually inherit? Um, there's a few different categories to look at depending on what family is living when a loved one passes, or who survives you if you pass away. Um, if a spouse and children inherit, or if a spouse and children survive you, not everything automatically goes to your spouse. Oh no, there's a portion that would go to the spouse and a portion that would go to the children, depending on what all you own. What if you die with no children, but you do die with a spouse? Your spouse and your parents, if you have any parents who survive you, could end up splitting your estate. Yeah, it's not necessarily what you would have expected. If you don't have a spouse or children, then it could go to your parents, or then to your siblings, or then to your more distant relatives. And if you don't have any living relatives at all, then it may just escheat to the state, and the state, in its infinite wisdom, can decide what to do with that money or with that property. So you got to figure in some real world complications here: blended families, estranged relatives, minors inheriting property. Could be a lot of different variables there that could come into play. Um, so if you have your will prepared, you actually have the ability to choose who inherits what. You get to choose who your personal representative is. You get to reduce the likelihood of legal disputes and reduce the likelihood of excessive legal costs. If you have minor children, you can name who you want to be the guardian of those children, and it will make the probate process easier and faster by having those questions already answered through your will than being open ended for the court to decide based on its interpretation of state law. So getting that will, along with your other estate planning documents, is going to give you that peace of mind and protect your family, and your wishes. So don't let the state write the will for you. Take the time to sit down with an attorney and get this done right, and you'll be glad you did. And as I've told you in other videos, you really need more than just a will. You need to get your powers of attorney done. You need to get your advance directive done. Um, if you're getting older, you need to do some Medicaid planning and some asset protection planning. Uh, it's going to pay off in the long run, I promise. If you've got questions about any of this stuff, feel free to give us a call at King Law, and we'd be happy to discuss this with you. All right, have a good one.